This presentation is provided by Martin Fine and Alina Balistreri. We are from CRLS, Conflict Resolution and Legal Services, and this presentation discusses conflict resolution for special education. Considering the increase in special education students, legal requirements, and level of funding, it is a testament to the school staff, students, and their parents that quality special educational services are provided to so many students. However, when disagreement occurs, it presents a dilemma. The special education law provides parents a right to appeal the decisions of the IEP team through due process and litigation. Between 2000 and 2010, the number of federal special education cases doubled. Due process procedures drain a school district financially, consume staff time and energy, and impact the ability of a school to meet the needs of all students. For many parents who do not understand the complicated legal issues and may not have the time or be able to afford representation, due process is less realistic. And yet, with all the time, expense, and resources devoted to due process and litigation, there is no data or research indicating the current approach to resolving special education disputes improves the education of students. The farther a special education disagreement goes up the hierarchy of dispute resolution, the less control the district and the parent or parents have over the outcome. Interests are the underlying needs and motivations of the parties. Legal disputes state or convert interests into legal positions or rights under the law. But since the education of a special needs student is so dynamic and involves many important relationships, capturing all of the needs of everyone involved in a legal position or a right protected under the law is virtually impossible. Thus, while legal rights may ultimately be determined in litigation, at the end the parties may not feel that their most important needs and interests have been satisfied. The law provides for mediation, which usually occurs after a due process complaint has been filed. Special education mediation, provided by the Office of Administrative Hearings, is often successful in settling the dispute. But the damage may already be done. The trust and relationship so critical to the success of the student's education may be irreparably impaired. Effective facilitation and conflict resolution needs to occur at the lower end of the hierarchy of disputes, at the school site, to enhance the education of the student and reduce the drain on education resources. Parents are trying to obtain services to help their child succeed at school. When programs designed to improve a student's success are limited or not working for a particular student, special education may be viewed as an option to obtain services to help the student succeed. Especially when an issue of eligibility exists, the IEP team meeting is an obvious place to involve conflict resolution. In addition, conflict resolution may help with other types of special education complaints. Under the law, the IEP team is a group of individuals, as specified, relevant to the student's needs in education. The IEP team is responsible for developing, reviewing, and revising the student's IEP. The purpose of the law is for IEP team to work together to develop, monitor, and improve the educational result of the special education student. To many parents, an IEP team meeting can be a difficult experience. They are confronted with terminology and technical assessments that they likely do not understand. Despite the efforts of educators to make parents feel comfortable and explain the issues, parents may feel outnumbered and intimidated by the expertise of the educators. Lastly, the IEP team reality often results in the dreams and expectations of parents clashing with the financial and staffing constraints of the school. While a special education case manager may be designated, that person often does not have the expertise or training to run an effective IEP. The dynamics and legal issues at the IEP are so complex that training and facilitation is needed for a designated person to be accountable for the outcomes of the IEP meeting. While the law is explicit regarding participants in the IEP meeting, it does not provide for the process of developing an IEP or the steps necessary to achieve an effective IEP. Districts or SELPAs often provide policies and facilitation which may help with many IEPs. However, schools continue to experience compliance problems and costly litigation. One critical component that may be missing from a district or SELPA-provided facilitator is impartiality or neutrality. Impartiality is often referred to as the most important quality of a facilitator because it contributes to safety and trust in the process. Because of background and experience, a district or SELPA-trained facilitator may be perceived as having a bias towards the district. An impartial and neutral IEP facilitator imparts trust in the process and helps maintain the focus on the educational needs of the student. There are some simple steps that can be implemented to improve the IEP process. The first and easiest is to consider the physical setting. While schools are strapped for resources, with minimal effort and cost, a location can be created to conduct meetings that helps make participants feel more comfortable and engaged. While school staff needs to be cognizant of compliance issues and the importance of the technical aspects of the IEP, when a disagreement or concern arises, the meeting needs to shift to problem solving. For parents and staff, the education of a special needs student may be charged with important emotional issues. A facilitator needs both experience and a well-developed approach to keep the meeting dedicated to the needs of the student. Problem solving is a collaborative and participatory process. Let's imagine a disagreement over a particular program or goals and objectives. While considering a proposed solution, the pros and cons, or compromising on a measurable objective may at times be relevant. Problem solving involves more in-depth analysis and possibly pilot periods to evaluate the impact on the effectiveness of the IEP. Remember, it is not just data and information that needs to be transmitted, but also ideas and emotions are important. The bottom line is that the meeting should be designed so that the relationship by the end of the meeting is better than at the beginning. An IEP meeting is embroiled in human emotions and dynamics. The IEP team meeting is also regulated by a complex set of laws and policies. The research on disabilities, the effect of the environment and drugs, and best practices that meet the needs of disabled students continues to change and evolve. It is not surprising the IEP meeting is a challenge. An effective IEP meeting takes time and effort. Particularly when the IEP involves the potential of conflict, the IEP team must resist the temptation to rush IEP goals and objectives and obtain the parent's signature. The IEP pyramid attempts to simplify the process into a three-point approach. The meeting is an opportunity to explore the interests, shared values, and positive intentions to meet the educational needs of the student. The second point of the pyramid is principles, to remind the team to review the legal requirements and standards guiding special education. This step can be incorporated as a checklist through a comprehensive agenda and IEP format. This point also involves the IEP facilitator and the IEP team modeling behaviors that are productive to the IEP. Lastly, the third point is that the IEP will not be effective unless the emotional blocks and barriers are addressed. In summary, the goal of this presentation is to encourage more structured and effective conflict resolution of disputes in special education. This can occur in special education, but can also happen when the unique needs of students in regular education are in dispute and the appropriateness of special services are being evaluated. Effective conflict resolution at the lower levels, such as the school site, has a better chance of preserving and improving relationships between parents, students, and staff, and reducing the cost and waste of resources. The training to accomplish effective conflict resolution may be appropriate for school staff, parents, and advocates. CRLS has experience in providing these facilitations and in developing and implementing training programs. If you'd like more information, please see our website at www.crlsmediation.com or contact us. Thank you.